Your Honor, here this afternoon in case of Section State of Ohio versus Ramon M. Gaines, case number 24 CR 952 and 24 CR 1197. In case number 952, the defendant entered a written and oral plea of guilty to count 1 theft, a felony of the 5th degree in violation of 2913.02A1 of the revised code, and in case 1197, pled guilty to theft, a felony of the 5th degree in violation of 2913.02A1, as well as count 2 misdemeanor theft, a misdemeanor of the 1st degree in violation of 2913.02A1. At that time, the case was referred for a pre-sentence report and investigation, and at this point on a victim impact statement, a drug and alcohol evaluation. Today we're here for purposes of sentencing, and the defendant is present with his counsel, Mr. William Watson.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Gaines, I know, has a history, a criminal history. In fact, he's been in front of this court in the past. With these 2 cases, Your Honor, Mr. Gaines stood up and took responsibility for his actions. In fact, on the second case, it was a plea by information. I met with Mr. Gaines several times in the jail. He has expressed remorse for his actions. Ultimately, Your Honor, Mr. Gaines has some mental health problems, who has been on and off his medication at different time periods. Fortunately, while he's been in our county jail, he's back on his meds. He seems a lot more stable. While these cases, well, prior to these cases, I should say, Mr. Gaines was living in a house in the city of Cleveland on London Road. I'm going to refer to it as the London House for Mental Health. It's for individuals that needed housing, that had mental health problems. Mr. Gaines was there, and it was his hope that he might be able to return there at some point. That place gave him some structure in a place to live. I know that this court has a lot of discretion when it comes to sentencing today. If the court does not feel that a community control sanction is adequate, I would simply respectfully ask the court to consider running a concurrent sentence in this matter. Thank you, Your Honor.
Thank you. Mr. Gaines, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor.
But
First of all, I want to say that I'm sorry for any victim that was impacted by my decisions that I made. I also want to apologize to the court for being here. But I have issues and stuff that I deal with mentally, Your Honor. And it's like I tried to explain to the lady at the site place there, that when you're dealing with voices, it's days that I can't control certain things. And you might not understand it, people might not understand it, but I live with it daily. And I'm not here to justify anything. I'm not here to, none of that. I just need help, and I'm asking you for help. And I feel like prison is not going to help me. That would only probably kill me, if anything, because of my health. And I asked the court today for help. Please.
thank you, sir. Mr. Watson, anything else?
Nothing further, Your Honor.
For the state of Ohio, Ms. Linden?
Thank you, Your Honor. Your Honor, based on those factors under 29, B, C, D, and E, in this case, there was economic harm to Walmart and to Kyle Vargo, and some emotional harm as well to Kyle Vargo for the fact that the defendant actually came in his garage and took the motorbike out of there. There's $379.78 worth of merchandise on the original theft offense from Walmart that was damaged and could not be resold. Here we're looking at an offense that occurred and then another right after that. The defendant has a long history of criminal convictions, has been to prison before, has pending charges as well. And in these particular cases, not only did the defendant commit these thefts, but one of the tobacco shops, he attempted to commit a theft in there as well. So this is a pattern of conduct that just hasn't stopped. And so the state is recommending a prison term. As I indicated in chambers, there were 3 original days, on the 952 case and 2 original days on the 1197 case. Defendant has been in then since September 8th of 2024 to the present time. So we'd ask for a prison sentence to be imposed with credit for the appropriate time.
This court's reviewed the pre-sentence report and evaluation, the psychological evaluation. I've considered the facts and circumstances of the offenses involved in each of these cases, the nature of the offenses. I've considered everything said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29:11. For the factors in 29:12, nothing stands out in case 952 that makes it any more or less serious. As for 1197, the court finds the victim there to suffer not just the economic harm, but also psychological harm, as related by the prosecutor. Again, nothing makes either case less serious. As for recidivism factors, I mean, these are all, defendant's got a lengthy history going back 35 years when he was 12 years old. Juvenile court, criminal behavior continued as an adult, and it's just been consistent for 35 years. I was trying to count how many cases he's been to prison on. I'm not sure I got it right, but I know there's at least 14 cases he's been to prison on. Now, many of those cases had concurrent sentences, and I'm not saying there's 14 different stints that he did, but there was 14 sentences that courts imposed prison on for 14 different cases. He has not responded favorably to previously imposed sanctions. He has been on probation before multiple times and violated multiple times on probation. He committed the offense in case 24 CR 1197 while on bond in case 24 CR 952. So he'd been arrested and charged with the theft offense at Walmart, was out on bond, and then committed another theft offense at the same exact Walmart at the same time he stole the bike from the victim in the theft charge, felony theft charge. He comes in here today saying he's very sorry for what he did, but yet when he talks to probation, he didn't do anything. He didn't commit a crime. Says he didn't know the items in the cart were stolen until he was approached by loss prevention. Well, then he's not guilty of that offense, though he pled guilty to it. And we talked about at the time of the plea that he's not. I'm not gonna. By pleading guilty, he's admitting to what he did, and we're not going to argue later that he didn't do it. But sure enough, at probation, he basically said he didn't think the items in the cart were stolen until he approached by law enforcement, loss prevention. He was just asked by 2 females to help him push a cart out the door. So he doesn't accept responsibility there. And then in regards to this bike, he doesn't accept responsibility for that as well. No factors indicate recidivism is, aside from that, we go back to the recidivism factors. Even after these cases occurred, there's at least 2 other pending theft charges that occurred. And got multiple other cases pending right now, some for conduct that occurred even after these 2 incidents. Happened. So those are all factors indicating recidivism. Recidivism is basically guaranteed in this case. Nothing indicates it's less likely. In each case, the court finds under 29:13b(1 that the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing. There's no way this court could ever make a finding that this defendant is amenable to community control sanctions. He has demonstrated repeatedly that he's not.
Yes.
Therefore, it will be the sentence of this court that in case 24 CR 952 on count 1 charge of theft, defendant serve a term in prison of 10 months. Case 24 CR 1197, the sentence of this court that on count 1 charge of theft, defendant serve a term in prison of 10 months. On count 2, he serve 180 days. The two times in that case will run concurrent with each other, but the prison term in each case is to be served consecutive to each other. These are separate charges occurring at separate times. In fact, the second one occurred when he was on bond for the first one. So in regards to credit, the defendant giving him 152 days of credit in case 24 CR 952. Additional 2 days of credit in 24 CR 1197. The court finds in this case that consecutive service is necessary to protect the public from future crime and to punish the offender. The sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that he committed the second offense in 1197 while he was on bond to the court in 952, and that his history of criminal conduct demonstrates consecutive sentences are necessary to protect the public from future crime by the offender. The court's going to order restitution in case 24 CR 952 in the amount of $379.78. In both cases, the defendant's ordered to pay costs. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control in each case. And I need to advise you upon your release from prison in these cases, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. I think that covers everything. Is there anything else I omitted or need to address, Ms. Linden?
No, Your Honor, thank you.
Mr. Watson.
Nothing further, Your Honor.